Welcome everybody, and thank you for joining us today in this roundtable on the European Investigation Order, Challenges to Sovereignty and Fundamental Rights in the Digital Age, which is organized in the context of the Project LIFE4. My name is Sergio Vázquez. I'm a PhD student and researcher at the BUB University, which is one of the 6 partners involved in the Project LIFE4, a co-funded project with the Life Forensics. This project is carried together with the Joseph Stefan Institute from Slovenia, which is the coordinator of the project, the Universidad Politécnica de Catalunya, the Fachhochschule Sigmaringen from Germany, the Masaryk University from the Czech Republic, and the Universidad Autónoma de Madrid from Spain. LIFE4, as I said, is a co-funded EU project that started in November 2017 and that will continue, it will last until November 2019. It aims to examine the criminal justice access to digital evidence in the cloud computer environment. In particular, the LIFE4 aims to the identification of the state of the art in relation with the implementation of Directive 2014-41, which introduced the European Investigation Order, the identification of educational needs for judges and prosecutors, and the creation of collection and best practices used for the seizure and preservation of digital evidence. Last but not least, the project also aims to raise awareness on the use of the European Investigation Order mechanism and the digital forensics methods for investigation in cloud computer environment. The topic of today is a very interesting, very complex topic, and might trigger a lot of questions. And luckily for us, we have today a great panel to discuss it. For that matter, I would like to thank for being here Catherine van den Heining, criminal lawyer at the Brussels Bar, postdoctoral researcher at the University of Antwerp, and visiting professor at the UB. Professor Gloria González Fuster, who is a researcher professor at the UB Faculty Law and Criminology and member of the Law, Science, Technology and Society Research Group and of the Brussels Privacy Hub. Professor Mirel Hildebrand, research professor on interfacing law and technology, member of the Research Group for Law, Science, Technology and Society of the BUB. She's also chair of Smart Environments Data Protection at the Rule of Law Institute of Computing and Information Sciences at Radboud University, München. And Professor Paul de Hert, who is professor at BUB University, associated professor at Tilburg Institute of Law and Technology, and co-director of Law, Science, Technology and Society at the BUB, and who is also involved in this project. At the beginning, this roundtable is structured in 3 sections. The first part will be carried by Professor Hildebrand, who will discuss the history and practice of sovereignty. This should last 10-15 minutes. After a while, the panel is going to be able to step in and make the comments that they consider appropriate. Afterwards, Catherine van den Heining will lead and introduce the topic of law enforcement and procedural elements of e-evidence gathering. Again, the panel will be able to mention and comment and bring their insights and thoughts on this. And finally, if we have time, we would like you to make the questions that you would consider appropriate. That would be it, and with that, I give the floor to Mirel.
Well, thank you very much. This is a very exciting invitation, because I was slightly at a loss about the relationship between my talk on sovereignty and the European Investigation Order. I can see from the order itself that it's basically focused on criminals and terrorists, crime and terrorism, and not so much, at least not explicitly, on cybercrime. And I've written more particularly about the relationship between extraterritorial, beautiful word, jurisdiction in cyberspace. But of course, international terrorism and cross-national crime, where this is obviously all about, is increased and influenced by the existence, or whatever you want to call it, of cyberspace. Since 10 minutes or 15 minutes is a restricted space to talk about a topic that has an enormous history and many conceptual implications, and of course many real implications, I decided to focus on issues of sovereignty in relation to territorial jurisdiction, which is of course relevant here, and to look into the history and the conceptualization and the implications of precisely that. And I want to immediately start with talking about the making of territorial jurisdiction. So when I looked into the problems that surround extraterritorial jurisdiction in cyberspace, so basically this is about law enforcement agencies entering a computer on their own territory and via networked computers doing investigations in the territory of another sovereign state. This raises a whole lot of questions and also already, of course, a whole lot of answers, not in the intellectual sense, but in the fact that this is already happening. Though under international law, extraterritorial jurisdiction to enforce like investigations on the territory of another state is by default prohibited unless there is permission. So it's very interesting to see where the idea of jurisdiction and the idea of territory comes from. So jurisdiction, the term, was first mentioned in the beginnings of the 14th century. And it basically referred to the reach of administrative power. 14th century is not the time when there were sovereign states in Europe. So it's like a proto version of the kind of modern state that arose later. So jurisdiction, beginnings 14th century. Territory, the term territory stems from the beginning of the 15th century, a full century later. And this is about land under jurisdiction of a town, a state, etc. The interesting thing is, of course, that it seems to be that the notion of jurisdiction preceded the notion of territory, and that means that originally jurisdiction was not necessarily tied to land. Now, I'm going to very quickly discuss something that would actually need hours and hours. I'm going to talk about the making of territorial jurisdiction, amongst others by the technology of cartography. So the fact that at some point, let's say during Renaissance, suddenly this helicopter perspective appeared in the arts, in the sciences, the geometric perspective, and this worked out in the terms of geography in the emergence of cartography. It has a wonderful description by Ford about how the invention of territorial jurisdiction, which was of course not something created by God or nature, it was something that required hard work, we invented it, how that invention depended on cartography. And he basically says, look, based on the cartography, so based on the fact that we could take this helicopter perspective of geography, authority became something that was exercised by an area instead of depending on status or family. So this was a new type of authority. The fact that the borders were geographical borders that were determined means that in a sense they were very clear and simple. They didn't depend on who exactly lived within those borders or their status. That's the second point he made. The third point is that this actually implies a rather abstract definition of territory and territorial jurisdiction. He basically talks about the rule of empty space. So whatever is in that space on that piece of land is ruled under the authority of whoever is ruling. And I'm still avoiding the term sovereignty. What was very interesting, fourth point, is that by using cartography, it became possible to produce a gapless map of contiguous, mutually exclusive political territories. So as soon as you draw that line, whatever is inside one political territory and jurisdiction is outside that of the others. So there is the mutually exclusive thing that was absolutely new, though for us it seems to be self-evident. This has a number of implications. It basically grounded what we have later begun to call the Westphalian order of international relations and the combination of internal and external sovereignty that, of course, depend on each other. Without internal sovereignty, there is no external sovereignty, because then the sovereign doesn't have enough military power to make his point as an equal among the other states. Without external sovereignty, there is no internal sovereignty, because basically you would be submitted to other commands. So territorial jurisdiction is deeply artificial. It's not at all based on some sort of organically grown Gemeinschaft or a nation. That means that the community, or let's say the population that is inside those borders, must be constructed in terms of a community. For instance, le nation in France. So in traditions have to be invented. Think of the rule of time, putting the clocks within one territory, within one jurisdiction, equally. Before that time, in every village, depending on the state of the sun, there was a different time. Well, and of course, the things like the national language. There were fierce attempts, reasonably successful, to create something like an organic community, which was, of course, an artificial community, within these borders. Now, this all seems to make territorial jurisdiction derived from the Latin term terra, which refers to the land, to that which nourishes you, that to which you belong, cultivation. But it turns out that perhaps terra is not the real root of territory. Connolly convincingly explains that the root of territory is not terra, or certainly not only terra, but terrere, again a Latin root, which means to frighten, to terrorize, and to exclude. So Connolly, after a long explanation for which we now don't have time, says a territorium basically is a place from which people are warned. Now I move to the concept of sovereignty. We move to Baudin. Baudin made sort of the same move from all sorts of particular types of authority or attempts of authority. Maybe it's better to speak about power, the power of different lords and overlords and underlords. And Baudin basically found that this corrupted the authority on which the res publica rests. So his idea was to prevent such corruption. And he discriminated between three powers of the sovereign, and this is in French, but we're in Brussels, so I assume everybody speaks French. It's better not to translate it. The puissance publique, the commandement, which is basically the move from suzerainty to sovereignty. Suzerainty is the time of feudalism, with the highest overlord being called the suzerain, but the suzerain was very dependent on his lords. There was a very strange asymmetrical reciprocity that meant that the suzerain was in a continuous process of negotiation. He basically could not take unilateral decisions. He always needed some form of consent, depending on military and economic power. And Baudin basically says we have to get rid of that if we want to have a res publica. The second power is the second attribute of sovereignty is the continuité de la puissance publique, by which he means the move from the rule of men to the rule of law. So again, this is trying to move away from corruption, from arbitrary rule, and to say we need a sovereign that when the person that embodies the sovereignty dies, the sovereignty itself doesn't die or suddenly change. So people have certain expectations of their sovereign. They are dependent, monopoly of violence, on their sovereign. So they want to have some idea how the sovereign will act. And this must be done in terms of laws and not in terms of the arbitrary will of a particular embodiment of the sovereign. So, le roi c'est moi, that's not Baudin's sovereignty. The third attribute of sovereignty is the puissance absolue, and of course this has given rise to endless misunderstandings about Baudin's sovereignty. It basically refers to the fact that the sovereign is independent from his subjects. He does not have to negotiate. So all talks about horizontal government and negotiating with all sorts of stakeholders, this is precisely what Baudin then warned against, because he said this will leave the subjects of sovereignty in a mess, because it will all come to depend on power relationships. So basically, his concept of sovereignty is meant to safeguard the state against corruption and the influence of warlords. To sum all this up, territory can be defined, understood, as sustaining lands that sustains, cultivates, feeds, nourishes a population that is occupied and bounded by violence. Without violence, no safety. Without violence, no protection. So that also means that occupation, to grasp sovereignty, precedes territorial jurisdiction and sovereignty. Of course, we know who elaborated on that, Carl Schmitt. And it also means that to give the law, to enact law, the competence to do so must first be captured. That is again occupatio. This is again Carl Schmitt. I'm not following Carl Schmitt. I'm following actually Gustav Radbruch, a minister in the Weimar Republic, who was not Carl Schmitt's dearest friends. But Radbruch very well understood that this point made by Radbruch is very important to understand, because otherwise you end up with all sorts of idealisms and you're not going to get anything done. Now, I can talk for hours, but I'll just close up to make it relevant, I hope, for what we're talking about. So the question is, what does legal protection depend on? And that is relevant because in the European investigation order, citizens of one state are expected to trust their own authorities, but also the authorities that their own authority trusts, other member states of the European Union. Which raises the beautiful question whether trust is transitive. So if A trusts B and B trusts C, does that mean that A has to trust C? That is basically what this order is about. And of course the answer is, well, that depends on quite a lot of things. So looking at sovereignty and territorial jurisdiction like this basically means it reasserts what we already know. Effective and practical legal protection, I'm purposely using the terminology of the European Court of Justice in Strasbourg, depends in the end on national jurisdiction to enforce. National jurisdiction is based on sovereignty, internal sovereignty, principle of non-interference, external sovereignty, the equality of states in the international legal order. That also means that national jurisdiction in the end, think Grotius, which is also part of this story, but of course I don't have time to also explain Grotius. National jurisdiction is basically based on international law. So it is international law that attributes the attributes of sovereignty, even if it is states that co-determine the content of international law. The last thing I would say, and maybe we will meet that, is that why this is interesting is because the whole idea of territorial jurisdiction in the sense of mapping contiguous, mutually exclusive pieces of land is over because of cyberspace. And cyberspace is not a different space from the land. It's not like the sea that is basically defined by not being land. Cyberspace is always and everywhere. So it's not a separate space. It's not that you can be in cyberspace and not be in real space. That is not possible. That's possible for your avatar, but not for us. And we are going to be suffering. Our avatars have a different sensitivity. So if that is true, if the territorial borders on which legal protection depends are up for grabs, then my position is that we have to rethink and also reconstruct the borders of jurisdiction if we want legal protection. And I don't think anybody has yet figured out how to do that.
Thank you.
So,
Okay. Hello, everybody. So I don't know if you have all seen the last version of the program. The last version of the program is that Paul and I intervened after Mireille and after Catherine. Originally, I was supposed to talk 10 minutes about the European Investigation Order and data protection, and I had planned to talk about 3 points. But now I will have to speak twice. So my challenge, my dilemma is, should I give you now 1.5 points, or should I give you the 3 points in a more or less half-baked way? That's my main dilemma. So I will just give you the 3 points that I was planning to explain about the European Investigation Order and data protection, and try to relate this to Mireille's brilliant presentation, which is also a bit challenging. So basically I had 3 points, one on sovereignty, one on data protection, and one about the European Investigation Order as such. The one about sovereignty is related to this title. So the European Investigation Order challenges the fundamental rights and sovereignty in the digital age. And my question is, can we really say sovereignty in singular, or should we use it in plural? And I'm very happy to hear this presentation, because I think we could perhaps agree that there is not one sovereignty, but many sovereignties. Mireille was explaining in a beautiful way the many genealogies of this notion of sovereignty in relation to territorial jurisdiction. I think there are many possible ways to look at this relation. And for me, there are at least 2 important types of sovereignty that are relevant when we think about the European Investigation Order and data protection. One is sovereignty indeed in the sense of legal protection, who has this power to provide, the power and the obligation to provide fundamental rights protection. I think that in the European context is very, very relevant. Is it the national state? Is it the European Union who is sovereign in relation to fundamental rights? Who is the authority in a general way? And then there's this beautiful notion that keeps reappearing in policy documents about data sovereignty. Who is sovereign about the data? It doesn't mean really about data protection. That would be something different. Somebody is possibly responsible for the protection of the data, and somebody else has data sovereignty in the sense that they own the data, that they can decide what to do with the data, actually not just to protect the data, but also to use the data, to use it perhaps to provide security, to provide something. They have this sovereign power over the data and to process the data. Sometimes these 2 different sovereignties can coincide. Sometimes they can be different, and I think the relation of each of these sovereignties with territorial jurisdiction might be different. And I really also like the reference of Mireille to cartography. I wrote an article on the relation between data protection and territorial jurisdiction, and it was titled Unmapping Data Protection, because I think one of the challenges indeed when we think about data protection is to admit, to confess, to realize that data protection as such is most of the time unrelated to cartographies. It is unrelated to boundaries that exclude. When we think about the European Union, data must flow between borders. Of course, there's a special regime that will apply when you cross the border to a third country. But between the borders of the European Union, there are no borders. There's no exclusion of protection. You have to let the data flow. So what is the sovereignty in this non-border context? For me, it's a particular question. And of course the question also, how do we deal with the different layers of sovereignty and the fact that they do not coincide from time to time. This is one of the first point I had of my 3 points. The second one relates to the relation between data protection and this European investigation order, but more generally all the instruments, the legal instruments that allow for access to data from law enforcement, from authorities. We have been working on this, and when we think about what's the relation with data protection, with the protection of personal data, it's a challenging thing to think about this relation because it's a double relation. So it's a relation. This kind of instruments have at least 2 intersections with data protection, and the image is the fish or the snake. I never remember which animal is biting its own tail. It is the fish. A fish. But imagine an animal biting its own. So there are 2 intersections and they are interrelated. How does this relate? From when you look at this kind of instrument from a data protection perspective, you know that to comply with data protection rules, in order for somebody to process data, they need a legal ground, they need a lawful basis. So these kind of instruments give the lawful basis for this data processing operation. But then the lawful basis, the instrument itself, here comes the biting itself, has to provide some standards of data protection that are in line with data protection safeguards. So data protection is relevant twice. You need an instrument, but you need an instrument that is good enough, it provides enough data protection safeguards, so then you really have a compliant instrument. So we have to double check the existence of instruments and also the quality of instruments. That's the main challenge. Then when we assess other instruments, other possibilities, like the future e-evidence instrument, we have to make this effort. It's not only saying, okay, there's a lawful instrument, there's an instrument allowing for access, then it's fine, or there's an instrument that provides some safeguards. Is it covering the right scenarios, and is it providing the right safeguards? That was the second point. And the third point, in relation to European investigation order, is that indeed it looks, from a data protection perspective, better than one might expect, or better than one might expect from the future instruments to give us. What is beautiful about this European investigation order, it is the fact that indeed trust is there, but it's not blind trust. There is an issuing authority and there's an executing authority that doesn't have to execute blindly, doesn't have to execute automatically. There is a possibility for this executing authority not to execute. There's a possibility to actually say stop. This data processing operation is not going to happen for arguments related to data protection. And it is this non-blind trust that is actually the data protection, the privacy, the fundamental, the sovereignty dimension of this authority. It has authority. It's an authority because it has the authority to say stop in the name of fundamental rights. This is not going to happen. Now, of course, this safeguard is very vulnerable, it's fragile. We can see that there are many ways to put it in danger. For instance, all these efforts to speed up things. Let's make things more automatic. Let's make an online form that allows this executing authority just not to lose time analyzing whether they should execute or not, just make it more and more faster. All this has implications in terms of fundamental rights. So this little time that it's taken not to deliver blind trust, automatic response, but just to question whether the authority should be used, the force should be used or not, that's the important privacy safeguard. So that is the third point, and with this I give the floor to Paul.
Yeah. Good afternoon. I already discussed briefly with Catherine. I'm going to say as few as possible about the investigation order because that will be the topic of her contribution. So I want to limit myself to some observations. It's first of all with linked to what Gloria just said. There is a history of growing data protection awareness in international criminal cooperation. And in the traditional MLAs, mutual legal agreements on collaboration, whatever they were, there was nothing on data protection. There was nothing on the documentation and the evidence gathered or received from colleagues and the respect that one had to pay to it. So everything was basically covered by older safeguards like professional secrecy, we're all colleagues, and so on. And I think we should not underestimate that. It worked really well, but it was due to refinement. Now, getting data protection in the international cooperation sphere has not been easy. We have done it successfully with the police because the police was eager to apply it to itself in exchange for more autonomy. So the history of international police cooperation could be read as a history of embracing data protection in exchange for more autonomy. And what did the police wanted? They wanted recognition at treaty level and at legal level, a recognition that wasn't given to them in the Interpol arrangement, because as you all know, Interpol is not based on a firm international treaty, but on an agreement that is accepted by member states. But it shows how difficult it was for the sovereign or the lawmakers to deal with a proper place for policing in the international sphere. All that changed with the Schengen Agreement, and it was a radical example of recognition, of giving recognition of a proper autonomous place to the police, which they already took in practice, and to translate that in law. So the historical relevance of Schengen is that it showed that law was capable of capturing this specific role of police that is actually quite controversial in a state. The police is doing the dirty work, and the cleaner work is given to the magistrates. And so the difficult point, and many member states struggle with that, is to delimitate the proper roles of the magistrates in the international cooperative sphere and the police. So data protection and police is a success story. What was hardly to be called a success was data protection and the magistrates. And many arguments, fake arguments and good arguments or half-good arguments, were used not to apply data protection principles to collaboration between magistrates. And one of them being, and it makes some impression when you first hear it, but then later on you think, well, is that everything? Well, the argument is that data protection is mainly safeguarded by DPAs, data protection authorities, that are administrative bodies, and it would be unacceptable in a rule of law, separation of powers, state-based state, that an authority, an administrative body would check on the judiciary. So that was the main argument to keep the magistrates out of the data protection sphere of obligations, and that was very successful. Schengen did not include the magistrates, and it is only, I think, with the EU Convention on Mutual Legal Agreement, Legal Assistance 2000, an attempt of the EU to work with treaties, that a first paragraph was built in, insisting on respect by the magistrates and those involved in international cooperation, also including the magistrates, to pay attention to data protection. So that was the first foot between the door of data protection in the life of the magistrates. But one can still say that the resistance is still there, and that the proper relationship between the judiciary and data protection is unclear. And and there are two ways of illustrating this: is by checking most of the treaties out there on cooperation in the area of criminal law. Most of them, the older ones, are totally silent, and the newer ones are rather diplomatic on it. And then a second illustration also of this diplomacy is the recent directive on data protection in the area of law enforcement. The applicability of the directive on the magistrates is a heated topic. And so it is very difficult, but I hope that Jurai can say more on it later on. But it's a difficult exercise to understand the implications of that directive on the work of the magistrates. Are they covered by it or not? Yeah. So that was the first caveat. There is a success, one can call it a success, that data protection becomes visible in this international cooperative sphere of police and the magistrates, but is the success a total success? And I think in the future we have to consider practical arrangements to complement DPA's supervision of data processing by supervision controlled by magistrates controlling magistrates. If not, we will never get there. So, and I think that is unmapped territory for the future that the EU is not willing to map because it's probably not within our competences. And so that was a first remark. My second about Mireille's talk is that we learn from Mireille's talk who all these notions are rather vague, are born in different mindsets, are obviously prioritized by some and less prioritized by others. So there's a full history of the to be told, and Mireille has done it, about these notions. I would say that these notions are contested in the normal meaning, that we are in doubt about the precise implications of these notions today, and that what is happening now, that state practice, for instance, will be one way of giving an interpretation to these notions. And so that is precisely what the Belgian magistrates, covered up by the whole policy establishment around them, are doing. There's a lot of unilateral actions by the Belgian magistrates. I think it is silently but clearly supported by a lot of policymakers in other member states, at the Belgian level and at the European level. They just want to see how far these Belgian magistrates can take this, and when first resistance will hop up. But so far I haven't seen any counterpower of importance, and this is making policy by accepting. Yeah? So, and of course, these magistrates that are playing this game have a unique position. They're involved in very precise, concrete cases that are of a nature of immediately capturing the heart and minds of the people. So I think they're actually very dangerous ambassadors of things that go beyond their concrete case. We have seen the same in the United States with the Apple encryption discussion. I think public interest discussion should take into account the experience of magistrates, but not be tested or battled on with concrete cases as a trigger point, because that is of a nature of confusing our good judgment. All that to say that we don't know what territory means, we don't know what jurisdiction means, we don't know what sovereignty means. And in that respect, I think a lot of confusion has been triggered by us wanting to live up to human rights obligations. We had, under the Clintons, a full tradition of humanitarian interventions, enormous debates in the area of international law and international policy making. And I think we all realize that there isn't a golden rule to be distilled from these experiences, but for some, these experiences were not the best. So there is a fierce debate, and it adds to the confusion. We have a feeling that there's a call upon us to disregard sovereignty claims and interest in the name of higher interest, but we don't know where to draw the line. So my thesis would be that we're confused by what some might call liberal cosmopolitans like the Clintons. Whenever there's injustice, we send our troops, and that what the magistrates are doing today is partly surfing on that wave of a certain benevolent attitude towards human rights interventions and so on, because we all like human rights, don't we? So, very dangerous game.
So, thank you very much for this great first intervention to all of you. And now we would continue with the second block with goes with the title Law Enforcement and Procedural Elements of E-Evidence Gathering by Catherine van der Heijning. Please.
Thank you. I made a PowerPoint basically just to limit myself in time. And I won't speak too long because as I'm a criminal lawyer and a visiting professor, that are evil twins for a brief presentation. So if anyone would want it, I mean, after my presentation, you can always ask for it. I'm just going to make one point because I think time is brief. I'm just going to make one point on the European investigation order, but I just want to start with preliminary remarks, so maybe I will make two points. First, and I think that's really a missed opportunity in the European investigation order, is that there has been no definition or even guidance in the preamble, I think, on what we do understand under e-evidence, or what data we're really looking at when we're talking about e-evidence. If you're looking at the discussions, and in particular the discussions that are not in public, the discussions that I have witnessed behind closed doors, and it's very clear to me that what the focus really is for law enforcement is not just data, is not just e-evidence, it is communication data. It is mails, it is telephone calls, etc. That is what for them is really at stake and where the real focus is. And that's also why the focus is on the ISPs, because it really are those instances where they are focusing on and trying to get direct access. That is not to say that other data is not important, it is very important, but in one reason or another, they believe, or law enforcement is looking at it, that the efficiency to get those data is higher than in communication data. And also other elements play, of course. If you're looking at, for example, biometrical data held by a foreign institution, for example, a foreign hospital, you will look mostly at personal data, Article 8. However, if you're talking about correspondence, in particular when you're talking about the substantive, the content part of correspondence, they're also looking at different fundamental rights standards, which are maybe even more important in criminal procedures. I'm thinking about self-incrimination, prohibition of self-incrimination, professional secrecy with the impact on rights of defense. And that makes it, of course, all the more delicate to get those data. My point as a preliminary remark is that we also shouldn't forget the other data. Because I do see actually in practice that those other data are often not met with the same guarantees, and something that I find very disturbing, and I feel it's under, it's not dealt with the same scrutiny, it's not being as visible in academic research, but also in media. It's that we are really limiting the protection of professional secrecy. And most of it is in the aftermath of terrorism, the anti-terrorism measures, but I think that is one for data protection we should really take into account. So then I'm going to go to where I want to make my point. I find it, I'm quite self-conscious to start that way, but I think it's quite known that Belgium was one of the countries that was a cheerleader for the European investigation order at the beginning. And one of the main reasons was e-evidence. It was e-evidence. And not just e-evidence, it was a focus on those communication data and to get faster and more easy access to communication data in different member states. And if you're really honest, there was also a side game because the real game was those American ISPs, but let's focus on the European Union. So they were really cheerleaders for that European investigation orders. And what they really wanted, or what most LIAs really wanted, was actually to get production orders, that they would get direct production orders against internet service providers. As you all know, that didn't happen. It wasn't included in the European investigation order, which was for many LIAs a real disappointment with the order. And secondly, what happened, and there I'm quite in line with what has already been said, there has been several layers of protection, data protection with reference to clear framework, provision, the charter in the preamble, etc. So the data standards that were already there, but also to national standards, because for the executing member states, there are a lot of possibilities to actually refuse, or even obligations to refuse to provide the data to the issuing state on the basis of data protection. One clear example that you will find, for example, if you get if the issuing state provides with an investigating measure that you don't have in your national legislation, there's a possibility, if it's not available, to get the same results, so to speak, with a different measure. With the exception, for example, of identification of communication data. So that's a clear example where you do get that backdrop of protection of data protection in European investigation, or the very clear. Of course, the most obvious is Article 20, where you see that data protection is a standard that has been included and really put in the spotlight of the European investigation order. A third element is, for example, the interception of communication, where you also see, if you've seen the first discussions on the interception, and you see what's in the order, you will see it has been several layers of protection have been added to what it was in draft version, or in discussion version, so to say. So that seems all very good, but it also drained all the enthusiasm of the law enforcement agencies. I've seen some prosecutors who were very active in the beginning in the discussions, and then lost all enthusiasm when they saw the direction this was going, and what they were basically saying, this is not helping us. Why do we want direct production orders? It's basically because of the speed. If we have, and that's always the example, if we have terrorism attack, we want to have the data now. And the European investigation order might speed it up a little bit, but not sufficient. And secondly, there remain different standards as to fundamental rights protection, in particular data protection, and that will also be a reason for many member states to say, we are not going to execute. And some are also making the comparison to the European arrest warrant, which has been quite effective in some member states, but is almost not applied in other different member states. So they say you will get a very differentiated application of the European investigation order. And so enthusiasm was drained. You see that in people not taking part anymore in the discussions on the draft and late implementation. And you clearly also see that the member states are not really jumping for joy to implement the European standard into national legislation. Belgium now was one of the cheerleaders, didn't implement the order in time, which is, just in time, It's like the CELDES, they also say it's in time, but... So, and there you really see what the focus was on, and they're still saying that, look, we still don't have what we actually want to have. So now you have the whole new discussion on a new instrument that should provide for direct production orders. There has been a non-paper of on several options for cross-border direct access, where the focus will be production orders. And what was, I think, quite interesting on the cross-border direct access non-paper and all the papers that were submitted in reply to that paper, was that you see there are very different standards how they are dealing with ISPs, in particular on sovereignty. That the standards are very diverse, and it will be interesting to see whether they will find any common ground. And the working group 29 already responded to say, wait, don't forget you've got your European investigation order. Because in those discussions on direct production orders, how are we going to get those communication data from ISPs, etc. Many times they don't even mention the European investigation order anymore. So basically what you will get, and then I'm coming to my main point, what you will get is that probably to the same data, you will have two routes. You will have the European investigation order with the data protection rules, the safeguard, fundamental rights. There's also a very elaborate and developed procedural part. How should the issuing state file for the order? How should it be received? Where is the judicial protection? Who should provide for judicial protection, etc. And they would have the other route, which would be the direct production order, and they would be, so to speak, they would exist apart from each other, and the standards wouldn't be the same of protection. It's quite clear that it would be completely disadvisable to have those two standards. But that is actually the route that it's going at this point. So to conclude, I really think that we should reassess whether the European investigation order will be practical and effective for law enforcement agencies, because that will be one of the elements that will keep on triggering law enforcement agencies to push the boundaries further on. But on the other hand, to have some kind of balance, or to have a strong balance with data protection, but as I mentioned in the beginning, also other fundamental rights, professional secrecy, prohibition of self-incrimination, etc., which are largely forgotten in that discussion. And there has been a very nice judgment on data protection, which most of you probably have read already in December, from the Canadian Supreme Court, with a very good dissenting opinion. And the judge was talking about a delicate balance. And I think that is lost. I think in the discussion that is lost, the delicate balance. And also from the side of the law enforcement agencies, who should also focus on finding the delicate balance and not only on pushing the boundaries. And so I think we are all in search for that balance. We haven't found it yet. And European investigation order has been a step, but will probably not be used as much for e-evidence as been hoped for in the beginning, for the reasons I explained.
Thank you very much, Catherine. We have 13 minutes left. I don't know if you want to join, and then we have to have 5 minutes for the audience to step in.
I'm happy to briefly come back to my 3 points that I did not cover completely. So indeed, I think that the issue that you were mentioning about some rights getting more attention than others, I think this is linked to this different type of sovereignty. And in terms of fundamental rights, clearly, from a European perspective, it's all about Article 8 and data protection. It has been a strong focus of the European Union. There's more harmonization than the other rights. They tend to be left to the national member states and to national perspectives. So that's also a difficulty, a challenge of dealing with these different layers of sovereignty. For the question of data protection, indeed, there's this question of the animal that it's biting its tail. It has to include data protection safeguards, but we have to make sure that that's the animal that really bites the data. It's not another animal that it's coming. And that's the challenge if you have these direct production orders. We have this in the European context, but also, of course, in the international context. How do we make sure that we not only have very strong mutual legal assistance treaties with data protection safeguards, but in a parallel way, all the practices are not happening. And when you look at the case law of the Court of Human Rights, it's not just about having data protection safeguards that apply, but also about preventing unlawful access. You have to be proactive in preventing, in knowing that unlawful access, the temptation of unlawful access is there. So you have to prevent this in some way. You cannot just open the door to many possibilities. And there's, to come back to the question of authority, who has the authority then to decide what is data protection compliant, what is legal and illegal. Indeed, when you have this direct production, when you have this direct access, normally it's not that we are losing completely the role of authority. There's always the starting authority, the requesting authority, the issuing authority that will be there, but then in that we're asked to believe that this authority is enough authority, that all the sovereign power of verifying compliance is dealt with. When we think about the international transatlantic context, is the magic power of the search warrant. If you have been discussing with American lawyers, you should not worry about anything in Europe because they have a very strong legal regime. They have these very strong safeguards standards for search warrants, and if they issue a warrant, everything is fine because they have probable cause and they have a lot of standards. So you should not worry about any other authority double-checking that. For me, the question is: this authority really the authority that relates to my data? That's again a sovereignty question. So that would be my main reaction, Paul.
Yeah, I'm still digesting what I heard. It is, and I fear, because this is of course it's going to be on YouTube, and we don't bring a happy message for magistrates. So I was thinking, let's be nice to them too. We should be aware of a two-track system, as you mentioned, with high standards that are never used, and one with low standards that is the routine base, and that is indeed something we should envisage and prevent. We have heard many good ideas about these production orders, and I like the clarification that behind doors it was all about e-evidence, mails, etc. And perhaps there is some practical wisdom then that we should apply, and it has been applied by member states with the Plume Treaty that has been negotiated bilaterally and later on incorporated in the EU acquis. Let's then call it by name. It's a very dangerous path, but it's a pragmatic one, and we should, and I will first explain the pragmatism and then the dangers. But what happened with the Plume Treaty? It was, again, a treaty not negotiated at the EU level, but secretly by some member states, and then it was an immediate success, a Justin Bieber top hit, and it spread around, and all member states accepted it in a way that should make the Commission in Brussels jealous about the acceptance of its own initiatives. And why was that? Because Plume was very detailed and very narrowly focused. It allowed member states to access number plate data in other member states. Nothing more, nothing less. Police wants to know who's driving this Croatian car in Brussels, and no more. And so that was that an enormous corruption of the traditional checks and balances ideas? I don't know, but it was apparently something the police liked. Another thing they wanted was to have a simple no-hit system with regard to fingerprints and other biometrical data. So Plume was a lot of discussions about it, but if you read it, it was about really very precise information. Yeah. Now, could we learn something from that? And I would say yes. Rather than shaping the whole mutual legal assistance with one practical need in our head, rather than doing that, we should look at this one practical need and perhaps give it a status apart. If it's about knowing who's behind an email account, then let's do something Plume-like, vulgar around this and no more, and see what this brings us. And I would welcome that way more than every other more ambitious project now. We all know that the European investigation order is, the text has been there for 2.5 years now, and it should have been implemented some weeks ago. So it's actually just starting. And it's a simple wisdom of impact assessing new legislation that you have to assess whether new legislation is needed in the light of the experience with existing instruments. And we don't have that experience yet. So I can't see reasonably how an impact assessment saying, yes, we need this new initiative upcoming now, can pass a strict impact assessment review. And we have seen in the other workshop of Life 4 that the magistrates are taking this for granted, but we first need detailed studies on the functioning of the European investigation order or the non-functioning. And I'm simply not convinced that the non-functioning is so crystal clear. We all saw with the the Catalonian example and the European arrest warrant, that the EU has gone too fast in expelling older guarantees in extradition law and the laws on mutual agreement, and we have a problem there that we're not going to cover with a human rights broad declaration somewhere or a provision referring to human rights. We need to be much more detailed. There are the interests of the data subjects and there are the state interests, and both are relevant here, and we should envisage, especially overviewing the political climate, that these state interests are also going to play. Yeah. And so again, I refer to Plume, which was negotiated between neighboring countries with a high level of trust. That might be the way forward. But the EU is about 27 nations, all going in different directions. And I think the state interest, and see me here now being concerned about state interest. Well, I am. The state interest are an important aspect of the puzzle, not only data subject interest. And I think, for instance, that there were wise techniques in the 2000 Convention on Mutual Legal Assistance by the EU text that brought in concerns for state interest. For instance, a duty to notify authorities when you can beforehand, and a duty to notify them in all cases afterwards when there wasn't an occasion or there wasn't the time to ask permission beforehand. Yeah? The simple rule spelled out in the 2000 Convention, and I think we need those rules in order to achieve the balance we are looking for between all the interests at stake. So to summarize, if it's really all about this, then let's perhaps use the Plume experience. That would be my first. But let's also consider concerns for state and data subject interest, and look at the way we have dealt with these different interests, often conflicting, but sometimes not conflicting in the past.
So, thank you very much. We have some minutes left. If you wish to raise some questions.
Yes, I have a lot of them. I'll try to make it brief. My name is Juraj Seifert. I work for the European Commission, Data Protection Unit in DG Justice. The first intervention, Professor Hildebrand, you were mentioning the sovereignty as defined by Carl Schmitt, but he had this pessimistic view of, that politics is about friend and enemy, and there always has to be some sort of a conflict there. And I think we are, in the EU at least, we are trying to build some sort of political union that is not based on that antagonism. So the question of trust that you raised, I guess we have to trust each other and not be in the relationship of friends and enemy, and therefore probably have to have a different concept of sovereignty. We also, as member states, decided to transfer parts of sovereignty to the union level. So I'm not sure whether this trust wouldn't mean in the end that, for example, if you are a German company and you receive a judicial warrant from a German judge, you have to disclose data in this example, and maybe it means equally that if you receive the same warrant from a Bulgarian judge, that you equally have to disclose data. So maybe that sovereignty is then, let's say, federalized in a way. So I was wondering what do you think about that? And then Professor De Hertz, you were mentioning administrative supervision of judges, and yes, this is it's fascinating when you read the European data protection legislation, excluding courts when acting in their judicial capacity from administrative supervision by the supervisory authorities. At the same time, the Charter in Article 8, Paragraph 3 requires that there is independent supervision. So then what sort of supervision would you ensure? And what does it mean, acting in judicial capacity? We can see that it's very unclear, that there are member states interpreting this meaning that only when the judge is actually adopting a decision, it means that he is acting in judicial capacity, and everything else is covered by administrative supervision. So that's on the one end, very narrow interpretation. and then we have wide interpretation of saying that everything the judge does is acting in its judicial capacity, even publishing judgments. This is what, for example, the Court of Justice of the European Union is saying. Even publication of judgments is acting in our judicial capacity, so there is no administrative supervision. So a large spectrum of interpretations and a large variety of solutions for this other type of independent supervision. Maybe some think that there should be a special judge that does data protection, something there should be some sort of ombudsman, something that it's enough actually to have the review process, basically to have the appeal, and through appeal courts then deal with the data protection claims, which I don't know how then they would address third-party data. So this is highly problematic, I think, and there will be a variety of solutions on the table. What you said that it's very far-reaching actually, this notion of human rights protection, and I agree with you that there is some danger in it, because for example in the GDPR we have a very, very broad territorial scope because we want to offer a lot of protection to everyone's data wherever they are and so on. But then you have other communities, like law enforcement communities, coming and saying we want to have the same type of broad scope for our stuff. So we want to be able to, in the same way, to go everywhere and ask for everything, because this is what you do with offering protection. So if you offer, if you have broad territorial scopes for legislation that offers human rights protection, then law enforcement sort of legislation will then use the same argument in order to have far-reaching measures, law enforcement measures. So there is a danger there. And then there was a discussion about whether we need the new proposal that will come, that will be published on 24 January, so very soon. When we didn't even tested the EIO, and whether we should use Plume as an example. I think Plume is caught in the same trap as EIO, because if you look at the interoperability proposal from December, it's basically saying Plume doesn't work, so we have to have something new. And we really know that Plume doesn't work. Have we tried the limits, have we tested the limits of the existing databases and systems before we are adopting this huge interoperability proposal? So I think it's a parallel, but it has exactly the same sort of strategy, that you have, you need something new before you tried whether the old one is working or not. Belgium was maybe a champion on EIO, but it's also a very big champion on e-evidence, and it's really pushing for the new proposal. And for me, the biggest problem in this whole discussions is I always think of Gevgen versus Germany, the ECHR judgment, which is about Article 3, but it has also obiter on dictum on Article 8. And basically the message of the Crown Chamber judgment is that whatever prosecution, police, courts do in order to catch criminals, it should never be easy for them to do that, because if it's easy, then it's prone to abuse. And my biggest worry is that in all these initiatives that I mentioned, the new ones, we are actually trying to find the easiest way without, for the prosecutors, for the police, for courts to get something, without actually assessing the necessity and proportionality of those instruments. So that is my biggest concern. And I understand why member states are pushing for this e-evidence. You see the UK-US agreement that is being negotiated, and if that becomes a model, then other member states will say, well, we will then have a bilateral with US on this thing if there is no European initiative. So, I'm really not convinced about whether we need all these new things. And the last thing I wanted to say, it was your presentation. You said that law enforcement authorities are very much interested in communication data. That is a revelation for me, because I was always under the impression that they are much more interested in subscriber information, in metadata such as traffic and
Yeah,
location
but connected
data,
to communication
and
data,
the
yeah.
content
Yeah,
data
yeah.
is not so much so
No, that was
interesting.
what I meant, but all the data connected to. So I'm not talking about only content of communication, because obviously in often you can't even access it anymore because it's not retained, but all data connected to communication.
Yes.
That's what I, that's
absolutely.
basically, that's what I meant with communication data.
Okay.
I wasn't speaking about content, but indeed,
Okay,
we're
then-
talking about the same thing.
Then we understand.
Yeah,
that,
yeah.
Yeah, so that's all I wanted to say. Thanks.
Thank you very much. I don't know if you would like.
Yeah, just just a short addition, because it might appear I might not be sympathetic to the issues that law enforcement is raising, but I am actually very sympathetic to certain issues they are raising, and one of them is emergency requests. The investigation order does not really went into depth or did not really provide for a separate circuit for where you can speak of emergency. It's one of the points law enforcement always keeps on bringing forward, what in cases of real emergency. And not every data, only a small percentage of all the requests are emergency, but there are those emergency requests in cases of child abduction, etc. And in that kind of cases, which should be very clearly defined, which should be limited, etc., then I do think there should be a shorter circuit where you should be able to access data more easily, however, with a very harsh scrutiny posterior. And I think that is really lacking. And there was for me, an interesting judgment of the European Court of Human Rights, Trabajo Rueda, that also focuses on that definition of what is urgency. I think that one is one of the elements that we should really look into, and to which I'm very sympathetic. One of the other elements where I'm also very sympathetic, and that is lacking and has not been dealt with sufficient review, is, and I don't know whether in other member states it's been mentioned, but there's one investigating judge in Belgium who always comes with the same argument, saying we want to access that data not only against the person suspect or accused, but also in favor of him. And if that is correct, then I think there should also be in the order or in national legislation there should be the possibility also for defense to ask for the investigation order to be applied, or production order to be applied, to get certain data to which they can't access actually for themselves to be exculpated, and that is not provided. And I have dealt with a lot of cases, and I've never seen an MLAT provided or request of the accused or the suspect. It's not provided in the Belgian legal system, for example. To have it like that, it's really at the mercy of a public prosecutor, and that would maybe be an additional element where I can really follow law enforcement. I think that would be a very good addition.
Thank you very much. We are a bit exceeding our time, but
Sorry.
Good evening. My name is Nathalie Prince. I work for the Belgian Ministry of Justice, and since my country has been referred to
Named
a
and
few
blamed.
times, I would like to react. Since we're running out of time, I'll limit it to the most important points. First of all, I would like to thank Marielle Hildebrand for her very interesting overview and the history of the notion of territorial jurisdiction, and underlining as well that it's an artificial term. I completely agree with your statement that we should rethink and try to reconstruct the vision that we have on jurisdiction, especially when it comes to cybercrime. For the moment of this kind of artificial jurisdiction, there are already different interpretations. We see that a lot for some when we talk about jurisdiction in cyberspace. Some people see the location of the data or the seat of the provider as the holy grail, and that's they being the only one who's most fit, most appropriate to verify that everything is done in line with the data protection requirements, but also other requirements on on procedural rights and fundamental rights in general. Other interpretations are the fact, or is the question, isn't the state where the person who is actually using this communication better placed to protect his or her citizen and should have something to say in the possibility to obtain information and under the conditions which that should be possible. And that's actually what is done by the Belgian legislation. It's not only, there was a reference to ordained jurist ambassador or magistrates, but they're actually applying what is since 2016 also in our national legislation as well, that there are possibilities to directly contact providers which are offering services on your territory, which are specifically targeting your audience. And since they are willingly present and offering our services, they should have some sort of possibility or obligation as well to cooperate. And that's a different interpretation of jurisdiction in cyberspace. And it's not just a unilateral Belgian interpretation. We see the same concept already in the Cybercrime Convention, where it's allowed and where there's a broad understanding. The Cybercrime Convention is an open instrument as well. So on an international level, there's a broad support for that interpretation, be it limited to subscriber data. Furthermore, in the GDPR, we agreed as well that we should look at where providers are offering services and not just where they have their seat or where they store their data. So in that reflection, we think there is still room for a new instrument, because when we go to the European Investigation Order, Belgium was mentioned as a cheerleader of this instrument, but it was actually one of the 7 member states who took the initiative. And the e-evidence question was not actually at the top of the mind of the people who were sitting around the table when they took this initiative. Of course, there are provisions on interception of communication, but they're mostly taken over as from what is in the 2000 MLA Convention. There are a few twists. So, for example, the notification system has been reversed, but besides that, there aren't that many innovations. As for example, you mentioned there's no alternative for the identification of IP addresses, for example, but what could be an alternative is my question to that. This was more a common understanding of there are no alternatives, so in that case we should just simplify our cooperation. So this instrument was not created or developed with the idea to resolve the issue of e-evidence and the obtaining of e-evidence. And not what we see in practice are that a lot of member states refuse to cooperate, or a lot of providers refuse to give this information directly based on certain interpretations that they should only cooperate with authorities where their seat or where the data is located. So we think there are 2 distinct problems, and the EIO will not resolve this question, even if we see that it runs perfectly for cooperation. It does not cover particularly this issue, so we don't think that will be a wonder solution. And having said that, we think that this phase we shouldn't just put aside the idea of having a new instrument on e-evidence and sit back and say we'll see in a few years. We think we should be daring and should be try to find a different interpretation. And I fully agree that's a delicate balance and it's an extremely difficult exercise to do, but there are a lot of elements already there. We are completely in favor of having this judicial review. There was mention to the notification system. These are all elements which can be included in this instrument, but I think at this phase we should keep our minds open and look at ways how we can create the necessary checks and balances to have a system which both respects all the necessary requirements for our citizens, but gives efficient tools as well to our authorities. And they're not abusing the cases in the media, saying here and they're not playing into the public opinion. They're faced with reality, what is in their limits of their investigation. So I think it's more than fair that they communicate the reality and the difficulties that they're dealing with.
So thank you very much for your intervention. We already exceeded our time, so we're going to leave it here. Again, thank you, and hope that you found it interesting.
Thank you very much.